The Eighth Amendment, banning cruel and unusual punishment, excessive bail, and excessive fines. The Eighth Amendment to the United States Constitution contained 3 important protections in the Bill of Rights. This amendment has only 16 words, but these words have shaped American justice for over 200 years. The amendment states, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." This amendment covers 3 areas of criminal justice: bail money, fines, and punishment methods. The Eighth Amendment's ban on cruel and unusual punishment came from horrible practices in medieval England. In medieval times, people convicted of treason against the king faced the punishment of hanging, drawing, and quartering. This brutality meant the person was tied to a horse and dragged to the execution site, then hanged but not killed, then cut open while still alive, and finally had their body cut into 4 pieces. This terrible punishment was first used in 1284 on a Welsh prince named David, and later on Sir William Wallace of Braveheart fame in 1305. These cruel practices continued for hundreds of years, until limited by the English Bill of Rights in 1689. This was a response to King James II, who had used extreme punishments against his enemies. The English Bill of Rights declared that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This language was a precursor for American constitutional protections. The American story of these protections began in 1641, when the Massachusetts Bay Colony created a body of liberties which included a right to bail and banned cruel punishments. The crucial American influence on the Eighth Amendment came when Virginia's Constitutional Convention adopted the Declaration of Rights on June 12, 1776. The delegates declared independence from Britain and adopted a framework for individual rights that would influence Thomas Jefferson and ultimately the nation. George Mason authored the Virginia Declaration of Rights, one of the best statements of American revolutionary ideals. Section 9 of the Virginia Declaration stated that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. The Eighth Amendment, ratified in 1791, used almost the same words. Originally, these protections only applied to the federal government. Later, the 14th Amendment's Due Process Clause extended them to state governments following the Civil War. The Eighth Amendment provides 3 separate protections that address different elements of the criminal justice system. The rule against excessive bail does not guarantee that everyone gets bail. It says that when bail is given, it cannot be set higher than necessary to serve legitimate government purposes. The main purpose of bail is to make sure a defendant shows up for trial and serves their sentence if found guilty. Courts decide if bail is excessive by looking at whether the amount is more than needed to meet these goals. Defendants who think their bail is too high must ask for a reduction. If denied, they can appeal that decision. The Supreme Court has ruled that bail can be denied when defendants are dangerous to the community. This rule is especially important today because several states have eliminated cash bail systems entirely. Instead, they use detention hearings and risk assessments. These changes attempt to address the constitutional problem of wealth-based detention, balanced against protecting public safety and the liberty interests of the accused. The Supreme Court has not clearly defined what makes a fine excessive. In cases with poor defendants who may be jailed for not paying fines, the court has used the Equal Protection Clause of the 14th Amendment instead of addressing whether the fines were too high or excessive. The court has made clear that large punitive damages in civil lawsuits are not covered by the Eighth Amendment. However, the court has suggested that civil forfeiture proceedings, where the government takes property related to criminal activity, might be subject to the Excessive Fines Clause. This question of excessive fines has not been definitively answered. The ban on cruel and unusual punishment is the most contested part of the Eighth Amendment. In 1878, the Supreme Court case Wilkerson v. Utah gave examples of punishments that would always be considered cruel and unusual: drawing and quartering, public dissecting, burning alive, and disemboweling. Each was done to William Wallace in 1305. This shows how the Eighth Amendment constitutional limits on government connects to their historical origins. the death penalty has created the most important Eighth Amendment court cases in American history. In 1972, the Supreme Court created a test in Furman v. Georgia to determine whether capital punishment violates the Eighth Amendment. The court outlined 4 elements for this analysis. Punishment must not degrade human dignity through severity or torture. Severe punishment must not be given in an arbitrary or random way. Severe punishment must not be clearly rejected throughout society, and severe punishment must not be unnecessary. In 1972, the court found that death sentences were being given arbitrarily, with similar defendants receiving different outcomes based on poor guidance to judges and juries. This randomness was cruel and unusual, which stopped executions nationwide for 4 years, while states rewrote their capital punishment laws to comply with the Supreme Court's guidance. In 1976, the Supreme Court approved revised laws in Gregg v. Georgia that required separate trials to determine guilt and appropriate penalty. These new procedures limited the randomness that had previously made the death penalty unconstitutional. On January 17, 1977, Gary Gilmore became the first person executed under a revised death penalty law when he told a Utah firing squad, "Let's do it." The Supreme Court has limited the use of the death penalty by employing evolving standards of decency. The court banned execution for rape in 1977, for most felony murders in 1982, for mentally handicapped defendants in 2002, and for people who were under 18 when they committed their crimes in 2005. From its origins in response to medieval torture practices to applications in modern criminal justice, the amendment's 3 protections continue to shape American law. Bail reform efforts, sentencing guidelines, and debates about appropriate punishment all take place with the Eighth Amendment as the guide. Constitutional principles enshrined over 2 centuries ago continue to balance the demands of justice with the basic requirements of human dignity and liberty in American law. The Eighth Amendment remains a cornerstone of American law. Understanding its history and implications helps protect against abuses of power. Like and share this video. Subscribe to Constitutional Soundbites. Explore the principles that shape our nation and combat constitutional illiteracy.